On the stand right now is Wendy Gambelis. She is the girlfriend of the victim, Knight. We are on cross-examination, and we keep hearing testimony of inconsistent statements and a lot of objections. This is the case out of Florida, manslaughter case. Defendant is facing 30 years. We almost had a plea earlier today. But we're going to go back into the courtroom and listen to what she has to say on cross-examination. Seems like it's confusing and convoluted and not really getting anywhere, but it'll be fun to talk about this when we get back with our jury expert. Okay, we're in a sidebar. Why don't we bring on Alan, our expert here? Can we do that? Talk to here, Alan. Okay, let's talk about this, because this case, she's been on the stand a while now, and we keep having to go to a sidebar and a lot of silence in the courtroom, objections. You are a jury expert, jury consultant. That's what you do, right? You help lawyers pick jury panels. You help analyze juries. What do you think the jury is making of all of this silence, sidebars, and objections?
It's certainly pretty frustrating for jurors. They get there, they have what they want to be a streamlined version of witness testimony, and so it can get very frustrating. They want to put together a narrative, they want to assess the credibility of this witness as other witnesses, and keeps getting interrupted. So they'll ultimately have an overarching perspective and view of how they see this witness as other witnesses where this happens, but it is disjointed. So they're going to have to focus and sit tight and just realize that this is part of the system.
Right, it is disjointed, and we're listening to the testimony of this prosecution witness, which is almost turning for the defense, because I don't know if you were following this earlier, but the prosecutor was not doing a great job using their own witness to prove their case. The jurors are going to be hearing a lot of he said, she said arguments, right? So in your experience with a manslaughter case, a lesser case, right? We're not dealing with a first-degree murder or a second-degree murder. Let's give a little background for the viewers here as a jury consultant. What does that mean? Do you just help with jury selection, or do you sit there throughout the trial and help analyze the jurors throughout the entire trial?
It's both. It's being there for jury selection, trying to decide what type of jury you want, really what jury you want. So it also, I tell people, it's really jury pieces.
Okay, we have a bad connection here, but we're going to go back into the courtroom. But just to sum up what his answer was, he does a little bit of both. He helps pick the jurors, and sometimes he'll stay throughout the trial. And I was curious, but let's go back into the courtroom, is whether or not, in this case, how based on his experience, jurors would react to such hiccups within testimony and such objections and silence and sidebars. But let's go back into the courtroom and see what is actually going to come out in testimony. Welcome back. I'm Carissa Kranz. Right there on the stand, you can see we're watching our main trial. This is the Demetrius Elder case, 2014 case out of Florida. A lot of sidebars while this witness is on the stand and cross-examination, a lot of objections, convoluted testimony, losing credibility for the jury. Also, another trial we are following here on the networks is the James Cawley case, another Florida case. Death penalty trial. We are in the second phase of that trial, and I want to discuss briefly that case with Alan Tuerkheimer, our jury consultant, who is with me as a guest, which I'm really grateful he is, because any death penalty case is a very difficult case to do voir dire on. And now we have the jurors who were selected during voir dire, the same panel, now get to decide in the sentencing phase, because he was found guilty on all counts of murder and burglary. Now they get to decide whether or not he'll be sentenced to death. As a jury consultant and specialist, how hard are death penalty cases to seat?
It's really difficult, because it's one thing for a potential juror to say that they could impose a death penalty, and it's quite another for them to actually do it. So when you're doing the questioning, whatever side you're on, you really have to really probe deeply into some of their values and their views on the death penalty, and then also their personality, because you have to wonder what will happen in the deliberation.
Yep. We're losing you on this connection a little bit there, but yeah, so it is a hard thing. If you're still there, I do want to ask you, maybe the connection will be a little bit stronger in this next question. Would you stick with the attorneys for the penalty phase? And sometimes these trials can drag on a week or weeks, and then the penalty phase is a whole other mini trial. Would you stay there to continue to evaluate and psychoanalyze the juror's mindset in case there's some jury misconduct that's happening?
I think from a jury perspective, psychologically, I think continuity is the best thing. For the juror, then things are continual and there's not any kind of change of hand or any difference in the way there's to the approach. So I think it's always good to just stick with it, even if you're on the defense and you think, well, we lost this, yeah, we're good with the death penalty. I still think that some jurors like to compromise. And so if there's any shred of interest in compromising, well, that's going to help the defense. And all they need is one of the 12 jurors to do that.
Okay. So interesting. It's great to have someone on set who can just not just talk about legal mumbo jumbo, but somebody who can talk about the mind behind the decision makers. Really, just that panel, they decide the fate of so many lives, and that's our justice system. We need to go back into our other trial, our main trial, another Florida case. It's the Demetrius Elder case. We had opening statements today. This is a manslaughter case. He's facing 30 years. It's a co-defendant case. They were going to be tried together, but they're actually now being tried separately. Right now on the stand, as you can see the live feed, that is the victim's girlfriend who just stood up. Let's go into the courtroom live and see what's happening there. That's Wendy Gambelis, the victim's girlfriend. She looks a little beat up after cross-examination and redirect. She lost credibility on the stand. With me is Alan Tuerkheimer. I wanted to, did I say your name right?
Tuerkheimer, you got it.
Okay. I wanted to talk to you about this. You know, we just listened to the jury be removed and then brought back in, a lot of objections, a lot of sidebars. You're a jury consultant, you're a jury expert. How are they taking this?
It's frustrating to be a juror, especially when this happens, because their time is valuable. And if you think about it, everybody involved is getting paid. They're all doing their jobs. The jurors aren't getting paid.
Okay, we're losing you on that connection again. So as you're saying, I'm going to recap. It sounds like it's frustrating for everybody. Everybody's doing their job. And even the jurors may not be paid, or they get paid minimum wage or something really small. It's not really anything worth speaking about. But it's a frustrating process. We're going to have to go to a quick break, but we're going to continue to monitor the courtroom, and the prosecution is going to put a new witness on the stand when we get back. So stay tuned and stick with us.
Welcome back to Law&Crime Network. I have our guest with us, if I get my earpiece back in my ear, Rahul Manchando. Thank you for being here. And you know, it's just TV, man. It's live. It's gavel-to-gavel coverage, so things are going to go wrong, like things popping out of your ear and showing up on TV with that sound.
Absolutely.
But it's great to have you here, nevertheless. You know, a lot like trial work, too. You can never anticipate exactly how your witnesses are going to go down or how it's going to be testified to. It is not an exact science. It's a human endeavor, and you just try to roll with those punches. But also, Rahul, great to be here, have you here. And we have Alan Tuerkheimer still here. Jury consultant. Alan, can you hear us?
I can.
Okay, awesome. Listen, you've had penalty phase jury picking experience, and Rahul's had death penalty experience. I've actually tried death penalty cases as a prosecutor. So I think we've got the three talents in the room that can break this down. Let me go to you as a jury consultant. What from the defense side or the prosecution side would you be looking at to position this case? I'm going to put you on both ends, prosecutor and defense. What's important here?
Sure. Well, if you're on the prosecution, you want to see who's going to, even though they're death penalty qualified, not only would a juror say it, but they have the personality and the Constitution to actually come through and render that verdict when it comes to it. Whereas it's really the flip side. If you're the defense, you think, okay, well, these people committed to be able to render the death penalty, but will this person render it? In my case, I think that they wouldn't. There's something about their personality or view of the death case where they don't have the same intensity, the same pro-death penalty intensity as other jurors that you might want to avoid.
I love that statement you just made about death penalty intensity, because the last week when we were on discussing this, some of our people that are in the chat rooms that are faithfully and dutifully watching these cases and has some great commentary thought it was a little unfair. And just so it's clear, Rahul, when we death qualify a jury in the beginning of the case, each juror has to say that they would impose the death penalty should the state prove its case and prove the aggravating factors, the predicate offense and the guilt phase and the aggravating factors. But as Alan is saying, it's the death penalty intensity that's really relevant to the jurors. What's been your experience with that?
Well, you know, there's a saying, who knows what evil lurks in the hearts of men? And the reality is anybody can say whatever they want to say. My experience has always been that people tend to say whatever they have to say at that portion of the proceeding, but you never really know until you get up there. And that's part of the problem that we're dealing with in this situation. I think that in this particular matter, it's a very emotional case, it's a very emotional fact pattern. I think there's a lot of people out there that would harbor certain feelings internally. But when they're presented with that situation where they're forced to make that decision, I think it would be very difficult to make that decision for a lot of them.
Yeah, and one of the things that happens here, Alan, and you know this, is at the end of the case, the judge basically tells them that you have to individually make a decision to vote for death. And it's been my experience as well, even when you have a death qualified jury, man, when you put it into each individual juror's hands, not collectively, but individually, that you're the person that has to seek execution, it's really difficult. Now, on the other end, we're going to take a break real quick, but I want to also talk with these guests with regard to those things that are important to influence a jury psychologically in a case where they're asking for death of another human being. Egats, we got so much going on here at the Law and Crime Network. We got this fascinating penalty phase in a case that we covered gavel to gavel in the Colley case. We got the Elder case, and there's things developing there. We're going to keep you on top of all the cutting edge stuff because our producers are on top of it all. But listen, I know, Alan, you got to go. You've been on for a while, but I got to ask you, if you're on the prosecution side, what's the most compelling aggravating factor or fact in this case? And on the defense side, what's the best mitigating factor that you would be talking to the lawyers about as a jury consultant?
Right, I think that, and keep in mind the prosecution has a lot of momentum. Jurors deliberated for a couple hours, and usually when juries start to deliberate, they go over the law, they talk about the verdict form, so the prosecution has real momentum. I think the big thing going for them is that he went in there and did it, and there's really nothing to refute that. He's saying that there's this whole notion of jealousy, and he tried to, that's pretty important stuff. And then,
Alan, I don't know if you can hear me, but we're having a hard time hearing you. So listen, I think we got the drift. Great commentary, appreciate it. Thank you for all the time that you put here at the Law and Crime Network. I'm sure we'll catch up with you later on during the course of the penalty phase here. So, Alan, you're going to be signing off, and we're going to just real quick, while we have a little bit of time left, I think there's some mitigation here with regard to this ongoing thing for a couple of days where he finds the sex toys, and then they're in court, and he's agitated about that, and then they gets this picture of the new boyfriend now that's doesn't have a shirt on, is mowing the lawn. I'm not saying it justifies it, but in a death penalty phase, we all know it was premeditated murder. That's not the issue. The issue is, does it catch one juror to say, it's not passion provocation, but it's kind of close? What do you think?
Well, absolutely. It could be, obviously it could be a crime of passion. It's over a period of time. But, in a situation like that, I really don't think that, in a juror situation, you're going to get a mixed bag, though. You will find some jurors in there who will sympathize with him in that level, because it is horrendous. These, the photograph you're talking about, the sex toys, very, very, very disturbing. So, you really can't predict it in that level. You can't actually say this is what's going to happen. You're going to get a few people in that may or may not go for the premeditation issue, but I don't see it, though.
One of the things, Rahul, that I kept digging on as a prosecutor, maybe it's just my in my DNA and my instincts, I would keep hammering, is that when he shot through the door, the closet door where those two women were, he went past one of them, the one who actually got shot, and went for one who he actually killed. And my point to that was there was testimony in this case that he blamed her Lindy for having basically encouraged his wife to step out. And to me, it's very purposeful, very premeditated, very goal-directed, as we say. What are your thoughts?
Well, absolutely. He's definitely grabbing for straws at this point. He's trying to, create a stopgap between the actual A to B scenario. But, he's grabbing at straws. He's trying to blame on another situation. I think that he's not going to get away with that. Not going to be very far with that. It's a very, very haphazard argument. But I don't believe that that's going to change the outcome at all. In my opinion.
Well, Rahul, we're also covering this Demetrius Elder case. This is a self-defense case, and I can tell you as a prosecutor that whenever you're in the self-defense world and you have to disprove self-defense, the medical examiner's testimony is highly relevant as to the mechanism of death, the mechanism of injury, and I'm told by our producers that we actually have in that case the medical examiner on the stand. Let's take a little look at the testimony and see what we can glean. Okay, welcome back. By the way, Rahul, I just got back from a little vacation down there in the Jersey Shore, and it was really hot and humid there, so I wear my orange tie because it's a little musty out here in the city. But I just found out a fascinating fact about you on the break, and I think our audience would really like this. You actually were at Boston University medical school for a 6-year program. And eventually decided it would be better to be a lawyer than to be a doctor. Am I having that about right?
Well, it's close to being right. I actually did all the classes for medical. I was doing the 6-year medical class. I did the histology, the pathology, gross anatomy, embryology, pharmacology, the whole 9 yards, so physiology. But the bottom of the ninth inning, I decided against it, became an attorney instead. And I think it was a much more rewarding choice. I actually enjoyed the law much better. There's a little bit more room for error. Right. And a little bit less empirical. But I do have that medical background in the sense that I enjoy it quite a bit in the science aspect of it. So I see all of my cases actually in the scientific method. And so that's why it's very difficult, I think, for me to, you look at a case and you wonder how anybody could lose a case, because when you've got forensic data, forensic psychology reports, forensic reports, it's very, very difficult to lose a case in the United States of America, especially if you have a scientific background. So I think the science has actually helped me win some of these cases that I've got dealing with, especially when you're going against poli-sci majors or history majors, things of that nature.
Well, I think our experiences form the way we view things and the lens by which we view it. And that is a fascinating background. And one of the reasons I had found that information, as I was saying to you, have you ever been to an autopsy? Because it's kind of a rite of passage in prosecutor world where they have the lawyers. Sometimes it's, in the old days, they used to be tricky and try to make you want to pass out. I'm not even making that up. They were like seeing whether you could pass the gauntlet, the test of watching it. But it is a fascinating thing. But I've also found that it's been very interpretive, too, when they're ultimately making a conclusion as to whether or not it's a homicide case. Right. And a lot of times could be influenced by the investigators' thoughts of the case in terms of whether they're going to call it one way or the other. Did you? And that could be a big problem for prosecutors if they don't check that before they go into the court.
Absolutely. And you look at things like contusions on the arms. You look at other things like signs of self-defense. If you could pull that out of the hat, you got the case right there. They can make any conclusion or make any case theory that they want to. But if you've got the data from the autopsy on your side, forget about it. That's literally something you could pull out. And there's a lot of telltale signs of a struggle. For example, self-defense issues. You get contusions. That never goes away. But that kind of thing. In this case, for example, the Elder case, I think there was some argument about whether or not a bottle was smashed on somebody's head. That was a major point of contention in this case because that would, clearly determine the course of this matter. So that's one of the issues that I'm gathering is something that's being contested right now, and a great autopsy would actually help along the lines with that situation.
Yeah, it's been my experience, though, that a lot of times they've been called the wrong way because certain injuries could be evidence of a number of different things.
Yes, sir.
Hey, we're going to come back with this fascinating subject in a couple of minutes on the other end of a break, and we're going to be discussing with you maybe some more medical science issues.
Love to.
Well, Rahul, they're doing the house cleaning prosecutors do, and it's funny. Laura Lux on our chat room says she wants to see the pictures and how the defense often tries to keep the pictures out of the view of the jury, arguing it's not relevant, but it's always relevant in a murder case. What are your thoughts?
Absolutely. There's two questions that I had in this thing. And I couldn't find it in newspaper clippings, but there was allegations that he had a knife, that he approached the car with a knife. But then they said that they couldn't find the knife, and then there was an allegation that there was a smashing of a bottle on his head, and then the detectives apparently said there was no evidence of any kind of contusion on the head. So there's a lot of questions that I have as well that I would ask, and I'm wondering what the facts are here. because clearly those two issues would absolutely alter, the destiny of this case. You got the stand your ground issue, you've got the self-defense issue. But again, I got a lot of questions on this matter, and some of the things aren't very clear. And I'd like to know the answers to those questions.
Raul, just real quick before we go back, I'm waiting to see if his mouth is moving, and the producers tell us so that you guys don't miss anything. But I'm getting to the graphic nature of the pictures themselves. And it is a relevant piece of evidence. But by the same token, man, when they see some of these autopsy photos, and I was an EMT for years, and to be honest with you, that bothered me less than seeing a lot of autopsy photos. Sometimes it can be highly prejudicial, yet it's relevant.
Well, absolutely, and it is prejudicial, and that's exactly why they want it in, or maybe they want it out, depending on your situation. I mean, it's going to have an incredible effect on the jurors, but at the same time, you got to look at it and wonder, which ones are going to be advantageous to your position. That is the question.
An interesting question happens. I had a death penalty case where they were admitting it's murder, it's premeditated. They were gruesome photos of a woman who was burned alive, who was pregnant, by the way, by pouring gasoline on her and lighting her on fire. The autopsy photos were absolutely by a professional who's been on scene and out. It was terrible. But we argued that they were relevant to show the mechanism of injury, and that was relevant in the penalty phase. But the Supreme Court upheld that ruling and said it was okay for the jurors to see. But when they looked at those photos, they were visibly moved.
Oh, absolutely, and I think that's a common tactic to get them to gloss over some of the statutory hurdles that you have as well. I mean, sometimes you really can't, nail down every single aspect of the statute, or you can't defend this under the statute. But those pictures can sometimes take them over the edge, and I think that's got to be handled very carefully, depending on which side you're dealing with, because I think it tends to muddy the waters, so to speak, of what's involved in the statute in terms of the actual matter.
Yeah, well, Raul, listen, I know that the producers are going to let us know as soon as something is going on inside the courtroom, so we have a little time to continue to discuss and debate, if you will, some of these things. But also, some states are a little bit tighter with regard to the death penalty and allowing certain admission of evidence as opposed to others. And Florida is notoriously a death penalty state. Yeah. There's not as many things that can get verdicts overturned. It's like, for example, in Jersey, when they reinstituted it, every single death penalty resulted in 0 executions, which is one of the reasons why they abolished it, because it was a waste of time and resources.
Yeah.
What are your thoughts?
Absolutely. Florida is just like Texas in that regard, the Fifth Circuit. I mean, I think that they're very, black and white down there, the rule of law, the whole, Southern culture, so to speak. You don't do the crime, you do the time, whatever the case may be. And up here in the Northeast, we're a little bit more liberal-minded. We tend to be a little bit more, British in that manner, where they've actually banned the death penalty. But Florida does have those, the issues about the stand your ground rule. We saw that in the other case that we saw earlier this year. Again, the stand your ground matter is something that really people in the Northeast don't really understand. There's no equivalence. The stand your ground rule. I mean, I think that, and you could, talk about that a little bit more. But I think that down there, the bottom line is, if you are the victim of a crime and you're about to be harmed in any capacity, you have an absolute right to defend yourself with moral force. And I think that's something we don't really see quite a bit down there.
Here we're dealing with deadly force, and,
right.
and there has to be an imminent risk of death or great bodily harm.
Correct.
And these terms, great bodily harm, will actually be read. Those are legal terminology which will be read. What I find interesting in the stand your ground laws, it essentially says you have no duty to retreat if you're in your home, for example, but also in Florida, your vehicle. Raul, you have no duty to retreat in your vehicle. And this case involves an allegation of some incident that occurred in a vehicle. And I'm just wondering, maybe I'm being too ethereal or over the top or too heady about this, but does the fact that this was, if the jury believes that Knight, that's the victim in this case, the prosecution's victim, was the aggressor and that they were in fear of great bodily harm or imminent serious death, if they leave the vehicle, do they still get the stand your ground protection, or is it only while they're in the vehicle? Am I being too precise, too microscopic about this?
No, I don't think so. I think that as long as they're in the vicinity of the car, internally or a little bit around it, I think you can consider that the car, just like the house in that sense. I think that clearly there's going to be some movement. The door may open, the door may close, but you're in the vicinity, inside or outside the car. I think you could use that defense pretty adequately. But what I find really interesting about this, that you had mentioned it, is that I also practice immigration law. And, one of the things that drives me crazy is that every single state has their own criminal law. And the federal government tries to sort of streamline it and say, okay, this is an aggravated felony, this is a crime of moral turpitude, and they try to put it under one umbrella. And I find it interesting to see the different states have these different sort of, defenses that just don't exist in other jurisdictions. And so in this regard, I find this to be a very interesting case to watch. And I certainly, when it comes down to the two issues that I mentioned earlier about the knife, did he have a knife when he approached the car? I don't think that question has been answered yet. I don't think adequately. Has it been answered?
Well,
I don't know.
You know what? Listen, well, that is why you have to love the Law and Crime Network, because we are gavel to gavel coverage. If we don't know the answer now, we know we are going to hear the answer during the course of this trial. This is a Dan Abrams production, folks. I love being on here with you and with our great guests, and for all you that are in the chat room. Let's go to a break real quick, and on the other end, we'll come back because we got a lot cooking here. Law and Crime Network, a Dan Abrams production. Rahul, I got to tell you, it's just the gift that keeps on giving this network. I'm going to tell you something you're not going to believe. Are you ready for this?
Absolutely.
Is the audience ready for this? We have an ultimate true crime giveaway now here at the Law and Crime. It's right up on the screen. Guys, take a look at this. 2 tickets at CrimeCon 2019, which is the place to be seen if you are into American true crime, with a hotel stay. Exclamation point. I'm not even just reading it off there. I'm reading it on this paper. We have also Meet Dan Abrams and a studio tour at the Law and Crime Network and a one-night hotel and travel voucher. So instead of looking at my notes, I have used the power of deduction to say, why don't I continue to look at what's on the screen there, because these guys are doing a great job. Also, a Creepy Crate subscription. And I'm told, I gotta be honest, the only thing I wasn't 100% certain of is a lot of creepy stuff in this box, and everybody says it's a great gift. But I love, in addition to that, the Kindle that's loaded with true crime books from the lineup. Okay, now listen, here's the thing. If I were to be given any one of these things, check me for each of the boxes. But apparently, you can go online to lawandcrime.com and go to the giveaway icon at the top of the page. Now, I'm not gonna lie to you. I actually thought in my mind, Raul, I don't know if my people are going to like this or not, but I also got a wife, I got a father, his 85-year-old attorney, all these guys on here now. There's no reason that they can't go in, but I'm sure if somebody from my family got it, people would be disturbed because it is that good and they would cry foul. So you should get on the lawandcrime.com, click on that icon, because this stuff is really amazing. You got to love the network. So, Raul, listen. We got to go into one more piece of this discussion that we were just talking about in the James Colley case, and that is getting into this whole thing about whether or not this impact testimony will make the ultimate difference in the jurors' minds, where 2 people are murdered here. And I think that the defense is putting on a credible case. We need to see whether or not they're going to develop it through expert testimony. Just give me your takeaway. In the end, I'm not holding you to it. You haven't seen all the evidence. Is the defense making a dent in the state's case, i.e. spare his life?
I think they are. As you talked about, but I think there's some things that they're omitting, and we may even start seeing some changes. Who knows if they're watching the network? Who knows? But the reality is, like we talked about earlier, I really think they need to be hitting those other 2 issues: the drug matter, the pharmaceutical issue. That's massive, in my opinion. That is massive, and not a lot has been discussed.
Okay, now we were talking about the defendant's decision not to ask the jury to spare his life. I can only go on certain axioms that we know in the law, and we say it's not that they're right, they're just kind of rules by the road that we drive by. And one that I always remember as a prosecutor was my bosses who were teaching me the art of trial work, is that defendants can get up there and literally snatch the death penalty from the jaws of victory for the prosecutor by getting up there with a sincere, impassioned explanation and a request simply to spare my life. We know this in sales. I was told when I was in sales, when I was a young man, you don't get something unless you ask for it. So I don't know. I mean, does this rub them the wrong way that the guy doesn't even get up there and say anything, even though they can't technically hold it against them? Thoughts?
That may, throwing your mercy at the queen, that kind of thing. Is that where we're going with that? But I don't really think they need to do that. That's exactly probably why he's not going to testify. That's why there's no elocution, because they don't have to. I think they feel they've got this in the bag, and they feel that he can only do harm at this point. And like I said before, there's a couple issues that we haven't, we see them on the horizon, but they haven't talked about them enough. Not enough that I can see this happening, but they do have a window of opportunity, provided that they play it the right way.
Well, that's a very interesting perspective that you came up with. It's your thought that the defense feels that it has done enough to at least nick one juror to say no death penalty, and that's all they need.
Absolutely.
So the only thing they would have done by putting him on is risk him actually talking his way into the death penalty.
Correct.
Yeah.
Absolutely. Is he a likable guy? Is it a likability issue? You know,
Right.
Is he credible? I mean, he's, you know, and that might be problematic. We don't know what he's like.
Yeah.
So maybe they know better than we do.
You know, it's interesting, and you wish you could get into the minds of what's going on the inside with the defense team. But I think the prosecutor's feeling pretty confident in their argument, although, again, a little nervous. Hey, let's go to the prosecutor's opening. Just show a real quick clip, and on the other end of that, come back and discuss it. You're at the Law&Crime Network, gavel-to-gavel coverage. It's great being on with you. Yeah, I like this prosecutor's approach, Rahul. She's especially in a death penalty case, you got to be very careful to be staid, direct, to the point, not necessarily emotionless or unanimated. She's doing it on I like the pitch. I like the style of it. She's going through the charges. She's going through the aggravating factors. She's got a lot to work with. And the defense has one thing I would say is the worst factor of all. I've talked about it over and over again, is that she's reading those aggravating factors with respect to two separate victims. And that's a lot of death for them to overcome and mitigate and give them life. What are your thoughts?
I think you're absolutely correct. I mean, the prosecutor is definitely, she's definitely leading the show. She's definitely going down and kind of laying the scope of the law in the land. And you're right about that. You know, the defense counsel does have a challenge, but I think it's very interesting what you had said earlier about that he's not going to do the allocution. You know, it could go either way, right? What does that mean? Could it mean that they think they have it in the bag? But then I was just thinking about earlier during commercial break. Maybe that's also because they're a little nervous. Mm-hmm. Maybe because they feel that, you know, maybe they really don't want him out there because maybe they want to stick to the law and the facts and maybe try to get the defense. So it could go either way. Do we know what they're thinking? That's the question. In your opinion, as prosecutor, why would somebody tell their client not to testify?
Well, thank you for asking that question. Here's my answer. Now, it's a good one because I had one case where the defense attorneys just did not like their client. And I don't mean that they weren't representing him, but they were like, the jury is going to hate this guy. Because there's even when he's saying he's sorry, he's not. And in that case, they actually got the judge to agree to have the lawyer do the allocution, which was something else. But listen, folks, we love being on with you. Rahul's been a great guest. He's got a great background, brought a lot of different perspective in there, and you got to love the Law&Crime Network. Look at that package that we talked about. Get on lawandcrime.com and click that icon. I'm dying to find out who gets it. I hope it's one of our people that are routinely chatting in the chat room. But this is a Dan Abrams production, Rahul, and you know that this is the real deal with the real deal guests, a great production team. Thank you for your help. Everybody behind the scenes that makes this work, as well as all those staff writers that are behind there. If you have any legal questions or cutting edge stuff you want to know, do what I do. I go immediately to the Law&Crime Network. I'm not saying this is an advertisement. I'm telling you, wherever I am, I go and I see what are they writing there. That's how much confidence I have. Listen, it's been great being with you. I will be back Wednesday from the 12 to 3 p.m. hour. Follow me at Bianchi ESQ. Thank you very much. Have a great day.